These are all people of the state of Michigan versus V. Levron. For the record, my name is Michael Sawicki. I'm the magistrate. I have retained counsel here, Mr. Levine, and Assistant Prosecutor Barbara Morrison. Mr. Levine, you want to put your appearance on the record, please?
Yes, thank you. Good morning. For the record, Joseph Levine, I'm appearing on behalf of the defendant in each of these files pursuant to MCR 2.117C2 at this point for the limited purpose of today's.
Thank you. Ms. Morrison?
Good morning, Your Honor. Barbara Morrison on behalf of the people of the state of Michigan.
All right, thank you. And I have Detective Garrick as the officer in charge appearing. Detective, did you want to state your name for the record, please?
Detective Garrick, Farmington Hills PD.
Thank you. All right, Mr. Levine, did you need me to read the charges to your client? How did you wish to proceed today?
Don't, Your Honor. I would just note for the record that Detective Garrick contacted me yesterday. He told me what the charges are. I don't have anything other than just the 1 count of second, 1 count of third, and 8 counts of fourth. If Ms. Morrison would be kind enough to email me a copy of the complaint, I'd really appreciate it. If not, we can deal with that later. But for purposes of the reading of the complaint, we'll waive that, stand mute, and ask that the court enter a not guilty plea on the defendant's behalf.
All right, thank you. Then I'll enter a plea of not guilty. Mr. Levine, may I ask your client some questions, please?
Of course.
Mr. Levron, can you just state your name for the record, please?
It's V. Levron.
Thank you. All right, and what I've done, Mr. Levron, is entered a plea of not guilty. I'm going to set a court date for you. And Mr. Levine, I note that you do this defendant already has a pending case with a court date of December 7th at 9:30 in the morning. I was inclined to set all these matters for the same day, just as a matter of convenience. Do you have any objection to that, or does your client have any objection to that?
I think it probably depends a little bit on the bond you're about to set, but as far as scheduling, Your Honor, I think that that's appropriate. The other matters before Judge Brady at that time, one of the reasons that we had set it out a little bit on the other case was to give some time to some of the pending investigations to see what may come forth with those. So I think it makes a lot of sense, certainly for judicial economy, to address them all at the same time. And we would be willing to waive the 14 and 21-day rules to accommodate scheduling it on December 7th, as you've noted.
Thank you. All right, so Mr. Levron, in order to accommodate the scheduling and as a matter of convenience, you do have another case that's pending. Typically, I would set your court date on these matters sooner, but do you have any objection to waiving the right to have these matters scheduled within 21 days so that I can set them all at the same time?
No, Your Honor. I have
Thank
no
you.
objection.
Thank you. Okay, so I'm going to schedule a probable cause conference on all 4 of these cases on December 7th, 2022 at 9:30 in the morning. And the cases are all assigned to Judge Brady as the other case is. So December 7th, 2022 at 9:30 in the morning for probable cause conference with Judge Brady. Mr. Levron, Officer Edgell, who's sitting there, is going to give you a notice for you to sign. Obviously, you'll be in touch with Mr. Levine and the court will send notices out, but you have a handwritten copy that's being presented to you, and the record should reflect that the defendant signed his notice to appear. The next issue is as to bond. Pursuant to Michigan Court Rule 6.106, I need to set a bond. I wanted to hear first from Detective Garrick. Did you have anything that you wanted to say on behalf of law enforcement as to bond?
Yes, Your Honor. The defendant is the focus of an ongoing investigation. In addition to the 7 prior charges, these 4 new cases bring a total of 17 charges where the defendant violated his trust as a physician and assistant hockey coach to sexually assault young players in various high school and junior hockey leagues throughout the metro area. The investigation encompasses several communities around the metro area, as well as multiple states. I believe he is a threat to the community and a flight risk. We're asking for a high cash bond, home confinement, and that he see no patients and maintains a GPS tether and no contact with any former players.
All right, thank you. Ms. Morrison, anything on behalf of the people?
We would echo that of law enforcement, Your Honor. The gravity of the nature of these charges and the multiple victims, we believe that a high bond is appropriate in this case. We would ask that there be no cash or surety, that it be a straight out flat bond. And in addition to, I believe the defendant has surrendered both of his passports in the prior case. But we would also like that as a condition of all of the bonds in all of the cases.
Okay.
Thank
And
you, Your Honor.
you indicated you didn't want, I mean, are you asking me to set a cash or surety bond? Is that what you're asking me for?
No 10% provision.
Okay,
No,
that's what,
no provision. Yes. Yep.
that's what I thought you meant. Okay, thank you. Mr. Levine, on your client's behalf, anything as to bond?
Thank you. He's 66 years old. He has no prior record of any kind. He's presumed innocent of the charges that have been filed against him in the prior case as well as this case. The prior case involves 4 counts of 3rd degree, 3 counts of 4th degree. The court in that case set a bond over our objection at $100,000 cash surety, no 10%, with conditions that he have a GPS tether, that he could only go to and from work, to and from my office, to and from court, and to and from any necessary medical treatment. He was also ordered to turn his passports in. By the end of the day in which he posted bond, he was fitted with the GPS tether. He had made arrangements to have the passports picked up by the Farmington Hills Police Department, which they were. As a matter of fact, the officer that came out to pick up the passports, he has 2. They mistakenly only picked up 1, and we made sure that the other one was delivered to the Farmington Hills Police Department the following morning. He's had no violations of his tether while this case has been pending. We were contacted. Detective Garrick was kind enough to call me yesterday. As the court knows, I'm dealing with a family medical situation, but despite that, within about 15 minutes of the call being made, Dr. Levin was on his way to the police department to turn himself in on these charges. He certainly is not a flight risk. He's been as cooperative as anybody could be. He's been in 100% compliance with his bond. I don't have any objection to a GPS tether. However, I think home confinement is overdoing it. The court in the other case also had ordered no contact with any minor children, which Judge Brady subsequently amended to no contact with minors and no unsupervised contact with minors to which he is related. I think that those are more appropriate conditions in terms of the tether with those allowances. In terms of no contact with former players, there's no objection to that request. In terms of the GPS tether, home confinement, again, I've made my statements about that. I think home confinement is unnecessary as long as he's limited as to where he's going. And again, he's been in compliance with that. I've verified that personally with his pretrial services coordinator. So I think he's a lot less of a flight risk than the people intend, and he certainly has less ability to be a flight risk as well. In terms of the amount of the bond, as I said, he's posted $100,000 on the other case, and he's remained in compliance. I think that all should give the court some assurances. In light of the nature of the charges on this case, I'm certainly not asking for a personal bond, but we're talking about 2 charges that are concurrent penalties with the 4 that he has in the other case, and 8 additional high court misdemeanors. I don't think that that warrants a bond certainly at or in excess of the prior bond. We would respectfully be asking that the court set bond in the amount of $50,000, 10%. If you want to split that up as 12.5 on each of the 4 files, I'm not sure how the court would want to do it. But I think if he's got a total of $150,000 at stake on all these cases, plus the GPS tether, the court has all the assurances it needs. He does intend to return to court. He's retained counsel to represent him, and he'll be there to defend these charges, Your Honor.
Okay, thank you, Mr. Levine. All right, so pursuant to court rule 6.106 and recognizing the statements made, and I certainly appreciate the fact that that the defendant has retained an attorney who is very respected with the court, and I appreciate that that the previous bond was posted, and that the defendant has appeared thus far as ordered. That being said, the court does find that at this point conditional release is necessary in order to ensure both that the defendant does reappear, but more importantly, to ensure the safety of the public. And I think that the biggest concern that the court has at this time is that, of course, we look at these cases independently, and bond was set in the original case based on what was presented at that time. the court now has before it. And while these are allegations, and certainly the defendant is presumed innocent, we do have a substantial number of allegations that span essentially every year from 2016 through 2022 now. And that causes concern for the court. I'm also advised that there are a number of pending investigations which appear to be potentially leading to more charges. And of course, that also concerns the court because now there are allegations of a pattern. And as I understand it, these incidents occurred with patients at the defendant's home, allegedly at the defendant's home, at the hospital, and at his office. And so recognizing those allegations and the circumstances as presented to me now, I believe that a substantial bond with conditions is necessary. So accordingly, bond will be set the same in all four of these cases. I'm going to set bond in the amount of $250,000 cash or surety with the conditions, in addition to the standard conditions requiring the defendant to appear for court proceedings and comply with any of the general conditions. In other words, not to leave the state without permission, not to commit any crimes while on release, immediately notify the court of any change of address or telephone number. I am going to order that he surrender his passports. I believe that he's already done that. And Detective Garrick, on the order, it does indicate surrender driver's license or passport. I'm just ordering that the passports be surrendered. I'm going to order as conditions that the defendant have no contact directly or indirectly with any of the John Does that are identified in these cases. The defendant is not to engage in any assaultive, harassing, intimidating, or threatening behavior or hostile conduct with anyone. I am going to order that a GPS tether be affixed prior to release from custody. Mr. Levine, I'm conscious of the fact that your client already has a GPS tether, and while it may take him some time to post bond on these charges, they may remove that tether, but I am going to order that it be reaffixed before he is released. I am going to order home confinement except for medical or legal matters as a condition of that tether. Additionally, given the allegations, I'm also going to order that the defendant not engaged in any unsupervised physical contact with patients for purposes of medical treatment anywhere. Detective Garrick, on behalf of law enforcement, was there anything else that you needed to address regarding the bond conditions that I've said?
No, Your Honor, thank you.
Ms. Morrison, on behalf of the people?
No, thank you, Your Honor.
All right, Mr. Levine, obviously any conditions that I've said, I know you can appeal those and raise those with the judge at any stage of the proceedings. Is there anything else you wanted to address for the record?
Just question. The court just said no unsupervised physical contact with patients. Is the court also allowing a GPS variance so that he can work? That's certainly something we would request, and that was a condition of the prior tether with which he was in compliance. And I will note for the record that having reviewed a letter from his employer, their policy is currently that he not have any unsupervised contact with patients. There's been somebody in the room with any patient at all times. As long as that's complied with, can he work as well?
Detective Garrick, yeah, I appreciate that. Detective Garrick, any comment in that regard?
Only to say that all these John Does were prior patients of his. I will leave that to the court's discretion.
Okay, Ms. Morrison, on behalf of the people?
Your Honor, perhaps could be tailored to no contact with minor patients. These were
yeah, these weren't just minors, Ms. Morrison. That's why I'm just going to leave it to any patients. I think the question is just, is there any objection? Typically, my initial order for GPS tether was that he be confined to his home except for medical or legal, obviously legal appearances or medical issues that he may have. The question is there an objection that he be allowed to go to work and home?
I leave that to the court's discretion.
Okay, all right. So, Mr. Levine, you said that was a prior condition. He was allowed to return to work?
It was and is.
Okay. All right, so what I'll do is I'll make it home confinement except for medical or legal matters that he may be engaged in or work.
Thank you.
But again, there's no unsupervised physical contact with patients for purposes of medical treatment anywhere.
Understood.
So whether it's at his home, whether it's at the hospital, whether it's at his office, he's not to have any unsupervised physical contact with patients.
Your Honor,
It won't, because a condition of the other bond is that he not treat anybody at home.
Okay. Detective Gearick, go ahead.
yeah, that's what I wanted to address is the no patients at home.
Okay. I
No
can
objection,
put
Your
that into order. I can add that separately. I kind of was trying to encompass that with what I was saying with the no unsupervised conduct, but that's fine. We can do no treating of any patients at home.
Thank you.
Okay. Anything else for the record, Detective Gearick?
That's all, sir. Thank you.
Okay. Ms. Morrison, anything on behalf of the people?
Nothing. Thank you, Your Honor.
Thank you. Mr. Levine, anything on behalf of your client?
Just clarifying, $250,000 cash surety, no 10% on each of the 4 case numbers.
That's correct.
Total bond of $1 million, including on the files that only have the misdemeanors.
Correct.
Nothing else to clarify.
All right. Thank you. Detective Gearick, just for housekeeping matters, I'll prepare the pretrial release orders and I'll email those to the command desk and to you as well.
Thank you, sir.
All right. Thank you. All right. Thank you, everybody.
Thank you. Is it possible to get a copy of the order as well?
Typically, I email them to the police and to the court. I think you can get those. Detective Gearick, do you usually provide that to counsel and to the prosecutor, or how do we do that?
Typically,
Only reason I'm asking
we
is the
don't
court is closed today.
Right.
I'm
no, I
sorry,
understand.
Detective.
Yeah.
Typically, we don't, but it's a rare occasion to have an actually retained counsel present during arraignment. So I have no objection to it.
Okay.
I appreciate it, Detective.
Yeah,
Thank you.
Detective, I'll let you stay in touch with Mr. Levine and you can provide that to him as necessary. And if Ms. Morrison
Okay.
wants a copy as well.
Thank you.
All right. Thank you, everybody.
Thank you.
We're all set.
Honor,